Good afternoon. Welcome on in to another episode of From Day One. Today we actually go to the competency hearing of the individual we had on yesterday's case where he said that he would let them answer anything for $100 and go ahead and search him for $500. Now this may take long enough that we may stretch over multiple episodes, but for now, let's begin.
We're on the record here, and we're in a competency hearing, and I wanted, there may be some subsequent appellate review of this matter, Dr. Williamson, so I'd like to go ahead and swear you in at this point. Do you swear or affirm that any testimony you give in this proceeding will be the truth, the whole truth, and nothing but the truth?
I do.
Now, counsel, I'd like to start the ball rolling, and then I'll give you an opportunity to ask questions. Dr. Williamson, could you first tell us a little bit about yourself, and putting this on the record, what your credentials and qualifications would be?
Yes, sir. So I am a clinical psychologist, Jeffrey Michael Williamson, and been in private practice since 1991 and in Florida since 1990. Well, I'm sorry. I've been in practice since 1991 and in Florida since 1992, going into private practice in 1996. I have a PhD from the University of Missouri, Columbia, Missouri, with specialization in child clinical psychology. I have testified in court over 2,500 times, and I'm currently in private practice in Melbourne, Florida.
Thank you, Doctor. Does either side object to the court eliciting opinions from Dr. Williamson in the field of psychology?
No, Your Honor.
No, Your Honor.
Dr. Williamson, I had entered an order calling for an evaluation of Ronald Russell Farnham for competence to proceed, and you received a copy of that order. Is that correct?
Yes, sir. Yes, Your Honor.
Now, you have reviewed various documents purportedly authored by Mr. Farnham. Is that correct?
That is correct, Your Honor.
And his pursuant to an appointment, I understand, made by his counsel, he appeared at your office for the interview that was contemplated by that order. Is that correct?
That is correct, Your Honor.
Now, we have, both counsel and I have reviewed
Your Honor, I specially visited on that matter.
have reviewed
I object.
Hush now. I've reviewed a document entitled Competency Evaluation of yours regarding this, and you authored such a document. Is that correct?
Yes, Your Honor.
Now, my impression of that document is that it involved impressions of Mr. Farnham, but it did not have the evaluation associated with each of the criteria for competence as would be typical and as would be called for by the order. Is that a fair description of it?
That is correct, yes, Your Honor.
Why was that? Why?
That Mr. Farnham refused to answer any of the competency questions or typical background information, invoking his right to remain silent.
Okay. Now, you reached some impressions, however, notwithstanding that invocation. Is that correct?
That is correct, Your Honor.
Could you share those impressions with us?
Yes, Your Honor. It appears to me that Mr. Farnham is suffering from delusional disorder, primarily grandiose and persecutory type. And that typically is a diagnosis that is part of individuals that have psychotic processes. However, you can have delusional disorder without hallucinations or thought disorder, things of that nature. I would add that having reviewed, and at that point there was only an initial document filed, actually a written note, I believe, from his mother, but having read over the other documents, I would add some concerns about, possible thought disorder. And I say that simply because the legal texts that or responses that were made by Mr. Farnham are difficult to understand. It seems very similar to what we would call a word salad type of presentation when we're talking to someone who is suffering from a psychotic disorder, and they're basically not making sense. There's what we call loosening of associations and referential thinking, where they will go back to what they've said before, but really there's a lack of coherence, if you will, in their oral presentation. So in looking at the written documents, and certainly I'm not a legal expert, but looking up some of the words and things that were used by Mr. Farnham and the general presentation of the documents, it would look nonsensical, if you will. It's not clear to me what point he is making or what his defense is, even though he, is making the point that he's able to represent himself. So all I'm saying is that in addition to the delusion that I definitely saw, I do have some concerns now about a thought disorder.
Dr. Williamson, I wanted to ask you about the nature of his apparent delusions.
Yes, sir.
Oftentimes, we see people who have some unorthodox beliefs here in court, and they sometimes are part of what might be characterized as a sovereign citizen movement,
I object.
where they
Sovereign citizen.
where
I object.
they
I
are
object. I object.
where they're oftentimes seeking to frustrate law enforcement and obstruct the processes in court.
Yes, sir. I'm sorry.
Is that a fair characterization from your impressions of Mr. Farnham?
Certainly I can see that as an interpretation, and I am aware of this sovereign citizen concept or idea. Having evaluated individuals who have taken that approach, I would say there is a distinction with Mr. Farnham, and that distinction would be, while I do agree that there's an attempt to, in essence, say that the laws and judicial process, do not apply to him, the reasoning is substantially more illogical, it seems to me, than your typical individual who is making that sovereign citizen, if you will, defense. So what I'm saying here is that there seems to be a lot more disorganization and lack of clarity. And even though when you evaluate individuals with the sovereign citizen concept, they often have presuppositions, et cetera, that are, let's say, equally unusual or distorted, but we could say persecutory delusions might be there as well. I would distinguish Mr. Farnham's situation because of the lack of coherence, if you will, at least from what I've read, as to what really his argument is.
Dr. Williamson, there's an assessment tool used for the evaluation of delusions and delusion-like beliefs. It's called the Brown Assessment Belief Scale. Are you familiar with that?
I am familiar with it, sir, yes.
Is that something that would be useful in evaluating the delusions or delusion-like beliefs of Mr. Farnham?
Well, certainly would provide an empirical basis beyond just my observations, and certainly can be done. Again, my concern would be level of cooperation, and if using that, my own observations, I'm aware of this instrument. I've not used it personally, so I don't know if it's a primarily observational measure or if it's a self-report measure. So I would have to look into that. If it's a self-report measure, then I don't think we're going to get any better information than we already have. If it's an observational measure, then it would give us a better, I think, empirical basis for my conclusion.
I was reading an article last night. It's entitled Integrating Non-Psychiatric Models of Delusion-Like Beliefs into Forensic Psychiatric Assessment. The author is Joseph M. Pierre from the Journal of American Academy of Psychiatry and the Law Online, June 2019.
Okay.
It states in part as follows. Assessing the pathological nature of beliefs is fraught with challenges. However, including the limited options in the Diagnostic and Statistical Manual of Mental Disorders, DSM,
Yes, sir.
For the characterization of delusion-like beliefs, DLBs, the expanded cultural sanctioning of fringe beliefs in the age of the internet, and the potentially conflicting agendas of clinical and forensic psychiatric evaluation. So my question is, if the assessment is so difficult, how can the court make this determination, or can the court make this determination with respect to competence where the defendant is not cooperating, where there's no, there has been no empirical assessment of his beliefs or delusion-like beliefs, or his delusions?
Well, I think we have, and if I understand you correctly, Your Honor, typically it is fairly apparent when individuals are delusional that, by the statements, et cetera, that they make or other correspondence. And clearly what I'm going off of in a major part is the, correspondence. You are able to identify some of the major parts of it. In application to, forensics, I think one of the questions that's being asked is this either malingered presentation or a just outright, attempt to obstruct the legal process. And that's where it becomes a little more difficult sometimes, is distinguishing between whether it is a legitimate presentation or malingered in some fashion. Regardless, part of the problem that I had with this evaluation was in exercising his, right to remain silent and not responding to, my questions. All I can say is that the effort wasn't put forth. The ability to observe the defendant was minimal. So in and of itself, my primary response to that was looking at the documentation, et cetera, that it did appear to me that there is actual delusional content. But if further assessment along more empirical lines, like using an instrument like that, is beneficial, I'm certainly more than willing to assist the court with that.
That brings me to my next question. And let me preface this with a quote from Through the Looking Glass, the classic children's story by Lewis Carroll.
Yes, sir.
Which the quote begins with the words of Humpty Dumpty. When I use a word, Humpty Dumpty said in a rather scornful tone, it means just what I choose it to mean, neither more nor less. The question is, said Alice, whether you can make words mean so many different things. The question is, said Humpty Dumpty, which is to be master? That is all. Is this merely someone who is just using language in a way that makes him feel special and important and different from other people in a way that tends to frustrate the processes of law enforcement and the court system?
I object.
Or is this someone who has legitimate mental issues? Mental issues with respect to. I'm just trying to get this out over his objections at this point.
Sir. Yes, Your Honor.
With so that this is a product of some legitimate, cognizable mental disorder. That's my question. Do you understand my question?
Well, yes, I do. I do understand your question, and I would say that having reviewed some of the documents and so on, I would be inclined to say that I think this is a product of a true mental disorder. But I also would add that in scientific reasoning, particularly in behavioral sciences, a both-and hypothesis is generally most correct. So I certainly would proffer the idea that we have a both-and, that there is legitimate psychiatric issues going on, but that there also may be a deliberate intent to frustrate, if you will, the court process.
Now let me ask one further question, and then I'll open it up to the attorneys. In the event that the court were to find Mr. Farm to be incompetent to proceed, and the court directed him to some remedial measures designed to restore him to competence, would he understand the obligation to appear for those, subject to some potential compulsion to do so?
I think that there is always that possibility that he would not comply, given our the compliance issues to start off with. I do think, however, he should be evaluated by, for example, circles of cares, forensic multidisciplinary team for competency restoration, and that would give us some additional information as to their observations and take on how much of this is a clear mental disorder versus a motivated attempt to frustrate.
I did have one further question. I said that would be my last, but I do have one more.
All right.
In your competency evaluation, you conveyed an impression that this the delusions or delusion-like beliefs that he has didn't pose a danger to the community. Is that correct?
Yes, sir.
Why is that?
Well, there's no evidence that I had from any of the information that we had any past history of aggressive threat, what we would call threat override symptoms, which with psychotic disorders, threat override symptoms are the ones that are more directly related to concerns about aggressive threats. So basically what that means is that the individual does have a paranoia, a persecutory complex, if you will. The world is against them, misreading people's behaviors, etc., as negative intentions. Okay, so we have a hostile, if you will, worldview combined with a inability to override or control intrusive thoughts, typically command hallucinations, and which is part of psychosis. And I have had no evidence and observation of him that, or what little I knew of his developmental history, that there was such threat override symptoms and inability to control impulses because of the strength, if you will, of the competing voices and so on.
Thank you. Counsels, either from the state or the defense, whoever would go first. Any questions?
So, Dr. Williamson, from what I understand,
This is Janet Roberts, the state attorney.
that
Yes.
you are recommending a facility like what was the name of the facility?
Circles of care, the forensic multidisciplinary team, FMT program, who does competency restoration training and provides psychiatric services for individuals who, have been deemed as having a psychiatric disorder, but are incompetent to proceed to trial.
And just to be clear, at this point in time, you are recommending that route. Is that right?
That would be correct, yes.
Okay, that's all.
Ms. Roberts, anything else? Any questions?
Good morning, Dr. Williamson. This is Jordan Roberts with the defense. So I know you weren't able to go through the full evaluation that you typically would do, but just based on your limited interaction with him in the office, reviewing the case file, and the different filings, I just kind of wanted to get your impressions on some of the competency standards, like his ability to appreciate the charges before him and kind of how the legal system works, what my role is.
Yes, ma'am. So first, I would say that that's one of the reasons that I am suggesting that I think that there is more of a psychiatric element or component to this. So the if you look at both statements that have been made and his various filings, it seems very clear to me that he does not understand, in essence, the basic roles, respective responsibilities of courtroom personnel. the fact that we have a misdemeanor case, which theoretically could be easily resolved with his cooperation, and he is responding in the manner that he is responding, certainly suggests to me that, again, there is a mental disorder behind all of that. And when Your Honor had asked me questions about the sovereign citizen, I would say that the vast majority of those individuals are using that kind of defense, if you will, if such is a defense, because they're facing serious charges. Those same individuals would be pretty unlikely, I think, to make such a defense on a misdemeanor case. So I do think that there is a reaction here to a misdemeanor case that strongly suggests to me that there is, again, psychiatric factors going on and so on. Secondly, and I may jump here to also our factor about the capacity to consult with counsel. Given his inability, it seems, to recognize what the actual charges are and the distortion by which he has interpreted it, the severity of the charge in his eyes that's against him, and an inability to, basically accept his defense counsel's representation and collaborate. I certainly would say that he's incompetent on the factor of what are the charges that are against him, what is a less or more serious charge, et cetera, and the understanding the adversarial nature of the legal process and the roles, responsibilities of courtroom personnel. It is clear that he sees the whole process as adversarial against him, but does not make the distinction between the state and the defense counsel, et cetera. That would then lead to the next one, which is I don't believe he has the capacity to effectively collaborate with counsel. I'm not there or able to pick up on what's going on in the courtroom, but I think we're likely seeing behaviors in the courtroom that would also indicate incapacity to proceed. And if his legal documents are any indication of what he would testify to, if he doesn't choose to not testify, right to remain silent, all of that also indicates to me that there is a underlying incompetence. So certainly it's possible that there is a deliberate and conscious attempt to frustrate this process. I would say that, however, that the illogical nature of the way in which that's being done, and I do like the Alice in Wonder looking through the looking glass quote. Yes, we have gotten to a place where the language is meaningless because it's just very unclear as to what he is referring to in regards to his own case, the logic of that, and what seems to me in trying to figure it out is almost blatant contradictions in what he is using as his defense.
So
I'm sorry, that was a long-winded answer, but.
Thank you. So just kind of based on having touched on the factors that you would have gotten into in the evaluation, if judge was to make a finding one way or the other today, do you have kind of an opinion or conclusion for him on whether or not Mr. Farnham may be competent to stand trial in this case.
So recognizing that such a decision is ultimately in the judge's purview, I do feel that he is incompetent to stand trial because of psychiatric factors.
Thank you. That's all I have.
Anything else for Dr. Williamson?
No, Your Honor.
Dr. Williamson, thank you very much. It's rather unusual to have the psychologist or psychiatrist testifying at these hearings because we
Yes, sir.
typically have a competency evaluation that addresses those various different criteria, but I thought it was valuable in this particular case.
Well, I actually appreciate it, Your Honor, because and if it is at all possible.
All right, we'll pause that right there. We'll leave this for the afternoon. Come back tonight for the conclusions. We march along here from day one.